I'm not sure how to find the exact receipt, but with that, I can show you with my app for my checking account where the $50 was withdrawn from MAD.
Okay, Short to Bigelow. If he says it's what it is, I'll take his word. Okay, so this is what I'm gonna do, because I don't want you sitting in jail and losing your job. But, I mean, this is a crime in which you got behind the wheel of a car with quite a bit of alcohol. And someone was injured. I'm going to order that you complete. When is that class registered for?
February 15th.
Okay, you need to complete that class by February 14th, I prove to the court.
It's February 16th. Right?
You're gonna provide proof to the court upon completion. And we have, let's see, looks like you still owe a current balance of. So you posted a bond. 300. Is that what you said? Hold on. Where's the bond receipt? Yeah, but. Oh, someone did it in the type. I'm like, why is this says $11,000? They didn't type it properly. Okay, looks like you did post a bond. Is that bond in your name? $1,100 bond that was posted.
Yes. Oh, did I pay? Like, did I pay the money?
Yeah,
My girlfriend paid the money.
yeah, I would say this is not your signature here.
No,
Okay. When you gonna pay this? You owe $1,300.
yes.
When are you gonna pay it?
I will pay it. If I can set up a payment plan, I can pay. The bond can't be applied to this. That's
If
what
your girlfriend wants to sign it over, it can. But it's not in your name. If it was in your name, I'd write apply, but it's hers. She got to write. She's got to sign it over.
How, is there a? Okay, can I explain the situation?
Sure, that's what we're here for.
My girlfriend paid the money but she didn't physically come and get me out of jail, so I would have to, message the person who did that, and would they have to come down and sign that over?
Whose name is the bond in?
What's her name? Brandy.
Brandy's not here today?
She's not.
Okay.
But she would be willing to do that though, because my girlfriend paid it.
Oh, so it's your money, ma'am?
Yes.
It's my money.
What's your name?
Shannon.
And you want to give him your $1,100?
He's worth it.
Is he?
He's getting back on track. Yes.
Oh, it's a lot of love.
I'm paying it back.
Okay, in cash.
Oh yeah,
Not
and
other-
everything.
Okay, she wants her money back in cash.
Yeah.
Okay, no, I don't care anything about the other things.
No.
Okay, so, when you're gonna have Brandy come up here and sign this over?
I don't know, read.
Or you can message her and ask her if she can do it like today or tomorrow.
Here's the thing, why don't you all come back on this, on the, when is our next court date after February 16th? Let me give you a new court date. I'm not sentencing you yet.
Okay.
Because I want to make sure you did what you're honoring what you're saying you're gonna do. Because I want to see if you really turned over a new leaf since 2021, or if you need to sit in timeout to turn it over.
I hear you.
See where we're going with this?
Loud and clear.
February 28th.
February 28th at what time?
1:15.
1:15. What else we got?
That's when the hearings are.
Oh, okay.
Your Honor, if she's able to come down and sign that bond over before then.
Oh,
would that
she can
be-
come anytime before then.
Okay, all right.
All I'm saying is that when you come back,
Yes,
I want to see that that was applied and that this remaining $300 was paid.
I can pay the remaining $300 right now.
Look, that's where, now we're talking. Okay, February 28th at 1:15 is your next court date for your sentencing on the violation. If you've satisfied all of my requests at that time, then I will discharge you. If you let me down. You see this guy right here? He's got some hardware. I have no choice but to have him use it on you to take you downstairs because you won't comply with my order, okay?
Yes, sir.
So don't let me down,
Yes, sir.
okay? Don't let her down. She thinks you're worth it. Don't let her down.
I appreciate
This is literally right after Valentine's Day.
it. I know.
Show her that you love her, okay? We're gonna get you a copy of your notice to appear. So there will be no excuse that you moved and you didn't know about your date. We're telling you, it's February 28th at 1:15.
Yes, sir.
Okay, we expect you to be here. You can appear via Zoom. If you comply with my order.
I'll appear in person
If you
either.
did it, you might as well come in person. You're gonna be ordered to report within a certain time period, okay? Do
Yes, sir.
you have any questions?
No, Your Honor.
Any additional matters for the record?
City.
So you're gonna pay, you said the remaining 300 today?
Yes.
Okay, we're off the record. Thank you.
Yes.
Okay, Ms. Blackman is here, Ms. Donnelly is here. What's going on with this phone? I don't see where there was an order for garnishment. I didn't sign it. We asked Ms. Gail, where is this garnishment? Because I don't see it in this file. Ms. Blackman,
Yes, ma'am.
what happened to you this morning?
I thought I was supposed to see Judge Milmore. The paper said Milmore. It was just an issue of being at the wrong court, but I got in touch with my attorney and found out I was in the wrong place.
Oh, so you logged into Magistrate Milmore's court today
I was there in person.
and she didn't tell you you were supposed to be here?
No, no one ever came in the hallway and said anything. I stayed until lunch.
That's unfortunate. And Ms. Dolly, are you ready to proceed on her matter?
Your Honor, when I got contacted by Ms. Blackman, I instructed her to come here as soon as possible. So no, if I could get a brief breakout room with her, thank you.
Okay, give me just a moment. Ms. Till, how are you?
I'm doing all right. Yourself?
Okay, you're here for
for
Eli, Mark Eli?
Mark Eli at 2 o'clock, and then 2:45, Tobin Sowers versus Garvey.
You got a jury demand. Did you file? Oh, then we take that off when we do that.
All right, I wasn't sure if
Yeah.
you wanted.
We take that off so it could be set for jury. Which matter are you here for?
I'm playing Mark Wadsworth here, Your Honor.
Oh, okay, you're.
And I just worked out, I just need to get a copy of the blank CD so I can get an agreement put together for you. The court officer says he's gonna get one.
Oh, is Idris Jones here?
Yes, he's in the hallway.
Okay, very good. Okay, and then this one's supposed to be canceled? Is that what that says? Yeah, Wang. Sounds good. Dismissal was filed for that. Okay, sounds good. Mr. Levine. Not really seeing you on my docket.
So I'm not on your docket, but there is a small claim that was paid off where there is a subpoena for a creditor's exam at 2 p.m. for Hunter Lansing Properties.
That was canceled.
We just wanted to confirm. Okay,
That was
so that
canceled.
was very good. Thank you. Thanks very much, Judge Simmons. Have a nice day.
Thank you. Have a good one.
You too.
Do I have a transcript? I don't know.
Cody didn't bring. He came, he didn't bring.
Cody? I don't think so. I remember him doing this to Bigelow. I need them to bring me Miss Blackman's file, that's all.
Thank you.
Okay, Ms. Donnelly, I have Ms. Blackman's file. So on the record in the matter of the people of the city of Lansing versus Adrekia Blackman, file number is 22L2709711. Council appearance.
Good afternoon. City of Lansing appears by Assistant City Attorney Greg Benker.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant Adrekia Blackman, who is appearing separately by Zoom.
Today's date and time set for a free trial and a bill to display a valid license. How are we proceeding on this?
Your Honor, at this time, we did have an adjournment for Ms. Blackman to be able to get her license. At this time, Ms. Blackman still owes on a ticket to clear her license, but she says she expects to have that paid within 30 days. So if the court would grant another 30-day adjournment, we expect there to be a valid license. Well, we expect to be able to resolve this matter at the next pretrial conference.
February 14th at 9 a.m. Ms. Blackman, are you going to remember to come to my courtroom and not to Magistrate Milmore's?
Yes, ma'am.
Okay, we'll see you on February 14th at 9 a.m.
Thank you.
No problem. I didn't sign this today.
Thank you, Your Honor. Have a good day.
Thank you, you too.
I think that's the last thing I have with you, Your Honor.
I think so. Thank you so much, sir.
All right, thank you. Have a good afternoon.
Same to you. Good to hear from Ms. Gill. If you can respond, you can send it, but I don't need a response if I can address this. We're on the record in the matter of LVNV Funding LLC versus Catherine Boland, file number 21-02977 GC. Ms. Boland, can you state your name for the record?
Catherine Boland.
Okay, today's the date and the time set for a hearing on an objection to income tax garnishment. This matter was actually scheduled for 1:30. It's 2:09. No one has appeared on behalf of LVNV Funding LLC. I have made contact with our clerk's department because I do not have any, the file I have here does not even have a copy of their request for a writ of garnishment that was per our electronic ROA issued back on October 19, 2022. So I can't see what they indicated to or alleged in order to get that granted. You do indicate, however, that you have never missed any payments. I do have here my last note in the file, which was from January 24, 2022, indicating that the parties entered a consent judgment and that you were going to make payments in the amount of $30 per month until August 6th, and then $50 per month. You were making, did you increase it to the $50 per month, ma'am?
I misunderstood. I thought we were supposed to have a 6-month review, Your Honor, because of my
No,
wages.
We didn't set it for a review.
I'm confused at all of this. They're being very nasty. And I wrote your clerk and she was very nice. I don't know if it's the lady next to you, but they sent me all the information and this is how I knew about this, what to do today. Honestly, ma'am, right now, my daughter's special needs, that's what I'm feeding right now. I apologize. Her income, and I just got approved for $600 for SSI because of my cerebral neuropathy from a car accident a few years ago, and obviously carrying her around for the last 13 years. It's caused a lot of nerve damage. So that's my income right now. And I'm trying to explain that to them. I'm not saying I don't owe finger hunting. That was the worst mistake I ever made in my life. I don't suggest that to anyone. But I'm doing and I'm paying, and then they're going to go behind my back and do this. I don't understand how. I mean, they were very
I don't know
nice.
if you misunderstood, ma'am, because you did sign an agreement here back. on
Yes, I did.
February
I think I
23rd.
did misunderstood. I thought we were having a 6-month review. I can go back to 50, I guess. That's the only thing I can do, or make up the difference. If you could tell me what the
Yeah, it
difference is.
says
and
that
make that-
defendant shall pay the judgment in installments of $30 each month starting February 6, 2022.
So 17,
Followed by-
September, October, November,
Followed
December,
by
January.
payments of $50 per month beginning August 6,
So
2022. So I
six
guess
times.
because you did an increase to the $50 is why they requested this, is what I'm assuming?
I'm not
I
sure.
don't
They're
know.
not very cooperative. I've tried to reach out to them, to the attorney.
I can't be sure either because they didn't appear. So because they didn't even appear, I'm gonna grant your request. And I'm gonna set aside the writ of garnishment. You need to make your payments of $50 per month, okay, ma'am?
Yes, ma'am, I appreciate it.
Thank you. You're all set.
And I apologize. Thank you.
No problem.
Have a great day.
Thank you. Okay. Okay, we're on the record in the matter of OPV Partners versus Idris Jones, file number 22-03128 LT. Council appearance.
Member of this court, Steve Gann, P7H29, appeared for the attorney of record, Mark Wasser.
Okay, and you're Mr. Idris Jones?
Yeah, I'm surprised you don't say my name correct. A
Why?
lot of people don't get it.
I mean, Idris, listen, we get some doozies in here. This ain't one of them, okay? Nonetheless, today is the date and the time that's set for your hearing. I do have a consent order for conditional dismissal. Can you state the terms in the record for us, counsel?
Yes, ma'am. I had the opportunity to meet with Finn in the hallway, and we've come up with a conditional dismissal of this case. Explaining to the resident that this case will be dismissed and stay dismissed as long as he pays a total amount of $5440.56 by February 15th. There's a payment plan in paragraph number 2 or 3 on that form. And the payment plan is starting tomorrow. He'll pay $500 and then he'll pay $1,000 every Wednesday thereafter. He's now obtained good employment, so he'll be able to cover that, he said. And as long as he meets those terms and gets it all paid by February 15th, this case will stay dismissed. I did explain that the numbers on the form do not include February rent. He's got to make sure he gets that paid as well. But since it's January, we can't include that. And I did explain 4.201I to him. He did sign the advice rights form, so he has been advised that he has the right to counsel, right to trial in front of the judge here, and right to come back in 3 days if he feels he does not understand what he's signing. But the judge will probably be very clear to make him understand today.
Okay, very good. And this is your signature here, sir? You understand all the rights listed here? Is that a yes?
Yeah, I read it correct.
Okay, you have any questions about these rights today?
No, I figured that as long as I pay on time, get everything situated, I'll be all right.
Correct. That's what this document, your consent dismissal says. That's, you're gonna pay that amount, and you're gonna pay it timely, and they'll stay dismissed. This was the one that told you about your right. So you have the right to be represented by an attorney. You wish to waive that right apparently because you came to court without an attorney, correct?
Right.
And then you had the right to have a trial. You could have a jury trial or a trial by judge. So you want to waive that right in order to enter into this agreement today?
Yes.
Okay, and so you have 3 business days from today. If you leave here today and determine that you misunderstood any of the rights that you waived in order to enter into this agreement, you can come and request to have the judgment set aside. You would have to explain or articulate to the court how it was that you misunderstood your rights, okay? Which might be a little difficult because I just asked you, did you understand all these rights? And did you have any questions? So that's why I do that. So you sure you don't have any questions?
No.
Okay, very good. And so I have here the signed consent order for conditional dismissal. I will affix my signature there, and then we'll get you a copy of that. Do you have any questions at this time? Any additional matters for the record?
No, ma'am.
You're all set. You're off the record. We'll get you a copy of this paperwork, okay?
Thanks so much.
Thank you. Okay, are you expecting your client to come?
I have not had contact with him for several months.
Okay, sounds good. So are you making a motion today?
I would be making, I'm not making a motion to withdraw.
Okay,
If he doesn't hear. But it doesn't appear that opposing counsel
that's what I was gonna say is the
has appeared either.
plaintiff's counsel here. Interesting.
And if they don't appear, I would be making a motion to dismiss.
Well, here it is, it's 2:22, so we're gonna call the case. We're on the record in the matter of Boone Walsley LTD versus Mark Eli, file number 22-00742 SP. Council appearance.
Felicity Till, P83961, appearing on behalf of the defendant, Mark Eli.
Okay, today's the date set for a hearing on a land contract forfeiture. This matter was scheduled for 2 p.m. It's 2:23. No one has appeared on behalf of Boone Walsley LTD. Council, how do you want to proceed?
Your Honor, I would request a dismissal pursuant to NCR 2.116 for plaintiff's failure to state a claim upon which relief can be granted due to their failure to appear today.
Okay, before we'll grant your request for dismissal, can you get us an order under the 7-day rule?
Yes, I'll issue the order.
Thank you.
Is that for you?
Thank you. You're all set.
All right, thank you. Would you prefer a scale dismissal?
Whatever's easier for you, that's fine for us.
All right.
Thank you. I like your hair color.
I'm sorry?
I like your hair color.
Oh, thank you.
Mr. Rosa, how are you?
I am good. How are you, Your Honor?
I'm well, even though, it's Tuesday and we're doing landlord tenant. I'm
Yes,
surviving.
I put it on the
You're
calendar
not here
today
for a
because
particular case. You're not here, you're just here in case you're needed, is that correct?
that is correct.
Okay, very good. And then Mr. Whitty has a 2:30 and a 2:45.
Wow, who cleans these?
Reports, never gets old, huh? What's your name, ma'am?
Marissa Trevino.
Night person.
Okay, do you have an attorney, ma'am?
No, I do not.
Okay, I'm gonna put you in a private meeting room with the plaintiff's attorney. That's Mr. Whitty, okay?
Okay.
Thank you, Your Honor. If Amy Sanderson joins, could you please send her in with us as well?
No problem.
Thank you, I appreciate it.
Either. Mr. McConkey, which matter are you here on? You're muted.
Sorry, I'm here for the Aaron Apartments LLC in Trevino.
Okay, I thought we put you in the private meeting room. Did you come out?
Oh, you might have actually just with my attorney in Trevino. I was not put in that yet.
Okay, you're in there now. Let me guess, Mr. Anthony's not coming? Is that what's going on this? Did we get dismissal?
Mr. Woody, were you all set, sir?
We have a conditional dismissal. I'm happy to put that on the record.
Okay. We're on the record in the matter of Aaron Apartments LLC versus Marissa Trevino, file number 22-03163 LT, council appearance.
Good afternoon, Your Honor. Norman Whitty appearing on behalf of the plaintiff, Aaron Apartments.
Hearing we have Marissa Trevino present via Zoom without counsel. The parties have met privately, and my understanding is that you've come to a conditional dismissal.
That's correct, Your Honor. I'm pleased to report that we were able to work out an agreement in this matter. The parties agree that rent is currently owing in the amount of $3,410 plus court costs of $164.25 for a total amount of $3574.25. We've agreed that Ms. Trevino will pay at least $250 per week starting January 13th and continuing until March 17th, 2023. And at that point, the balance owed will be paid in full. We also agreed that the amounts received from her under the payment plan will be applied first to current rent and lease charges, and then to the amount owed under the agreement. She understands that partial payment wouldn't stay issuance of a writ, and that if she misses any of those payments, we would have the right to come back to court and seek a judgment and a writ of restitution without any further hearing. We did discuss her rights under MCR 4.201I, and after that discussion, she emailed me her authorization to sign the conditional dismissal on her behalf.
Okay, Mr. Trevino, if you can unmute, please.
Hello.
Hi, okay, and you've heard what was stated on the record by Mr. Whitty as to the amount that's owed and the fact that the parties have entered into a conditional dismissal and that you will make a payment on that amount and the increments of $250 per week until March 17th. Is that what you understand your agreement to be?
Yes, I do.
Okay, and you understand your rights that you're giving up in order to enter into that agreement?
Yes, I do.
Okay, and no one's forcing you to give up your right to a trial or right to be represented by counsel today?
No, they are not.
Okay, and are you giving him consent to sign the dismissal at this time?
Sam.
Okay, you have 3 business days from today to return to the court. If you leave here today and then later determine that you misunderstood any of the rights that you waived in order to enter into this agreement, okay?
Okay.
You would have to articulate to the court how it was that you misunderstood your rights. Mr. Woody can sign the conditional dismissal with your permission, and he can tender it to the court. Any additional matters for the record?
Nothing further for plaintiff, Your Honor.
Thank you. You're all set, Ms. Trevino.
Thank you.
Thank you, Your Honor.
Problem.
Thank you, Your Honor.
No problem. Thank you. And then, Mr. Woody, we do have Mr. Kraft present.
If
Without counsel.
I'd be happy to talk to him and Ms. Brandenburg in a breakout room, Your Honor.
Okay, 1 minute.
Hey, Norm, you're all set with me, correct?
I am, Cliff. Thank you so much.
All
Have a good day.
right, no problem. Thank you too.
Your Honor, should I just go back to room 1 then?
That's correct.
Thank you.
Mr. Whitty, are you guys all set in the breakout room?
We are. You might have to bring Mr. Kraft back. I don't know if he's able to leave.
Okay. Were you able to reach an agreement?
Yeah, we're going to put a consent judgment on the record.
Okay. Okay, we are on the record in the matter of Briarcliff versus Charles Kraft, file number 22-02764 LT, council appearance.
Good afternoon, Your Honor. Norman Whitty appearing on behalf of Briarcliff, the plaintiff.
Okay, and Charles Kraft is present. He's actually in the courtroom, but we did place him on Zoom for convenience of meeting with you privately, Mr. Whitty. My understanding is that the parties have come to an agreement.
Yes, Your Honor. We've had a chance to discuss the case. The amount to retain possession is $73.9209 plus court costs of $165.94 for a total of $75.5803. It doesn't sound like either that amount will be paid or the unit will be vacated by the 20th. So we've just agreed to do a consent judgment and proceed from there. Ordinarily, I would have discussed Mr. Kraft's rights under MCR 4.201I, but I honestly have to say in my old age, I forgot to do that with him off the record. So I would defer to the court on that.
Okay, sounds good. Can you give me the amount again?
Sure, it's $7,392.09. Court costs are $165.94. So the total would be $75.5803.
Okay. Okay, so Mr. Kraft, are you willing to enter the consent judgment to either pay that amount or vacate no later than, what is the date? No, today is the 9th.
I have the 20th.
The 20th. Okay. By January 20th.
Yes, but currently I don't live there.
Okay. The property's vacant?
I assume ex-wife still lives there, as far as I know. There's a no contact order.
So you've already vacated the property?
I'm not allowed on that property at all since 7/18 of last year.
Okay, have you received all your personal items from that property?
I got some, but what I got is fine. But
okay. What is your ex-wife's name?
Marlene Nelson.
And she's still residing in this property?
I cannot tell you yes or no because there's no contact order. I don't know.
Okay, sounds good. It sounds like your client, Mr. Whitty, or it looks like your client is shaking their head yes. Mr. Ms. Brandenburg, is there a Marlene E. Nelson still residing in this property?
Yes, she is.
Okay, and are the parties going to be pursuing eviction against her?
Your Honor, both the complaint and the notice to quit named all other occupants. So it would be our position that she's included in that portion of the complaint and the notice to quit.
I do see the and all other occupants. Let's see. She would have received service by attachment. And has not appeared to any of the court dates. Okay, so as to Mr. Kraft, do you understand that you have the right to be represented by counsel at these proceedings? You also have the right to have a hearing. You can have a hearing by judge or a hearing by a jury. Do you understand that?
Yes, I do.
You're willing to give up those rights today in order to enter into this consent judgment?
Yes.
Okay, you understand that you have 3 business days from today to return to the court if you leave here today and realize you misunderstood any of the rights that you're waiving in order to enter this enter this consent judgment, and you can request to have the judgment set aside. You understand that?
Yes, I do.
Okay, you would then have to explain to the court how it was that you misunderstood your rights. Are you giving Mr. Woody a consent to sign the consent judgment on your behalf?
Yes.
Actually, you are in the building. If Mr. Woody sends it, we can get him to sign it. It's 3 weeks. If you can email that to us, Mr. Woody, we'll have him sign it.
Okay, I will have my assistant do that momentarily.
Okay, very good. Any additional matters for the record today?
Nothing for plaintiff, Your Honor.
Okay, Mr. Kraft, you can come back in the courtroom so we can get you to sign this paperwork and then you'll be all set.
Okay.
Thank you.
Yep.
Thank you, Your Honor.
No problem, thank you.